And thank you all for coming out tonight. You're hearing me in the back okay? Okay, Murph and I arranged for this talk before the Kavanaugh, whatever you want to call it, the confirmation process. So I've decided in putting together this talk that I would take those into account and leave some time to discuss the Kavanaugh confirmation and some of the issues I think are raised for it. But I do want to talk basically about three topics tonight. First, what the court does and how it operates. Second, how justices are selected for the court. And then third, that will have provided a context for some discussion about the Kavanaugh confirmation process itself. Now, when we talk about the U.S. Supreme Court, we often refer to the court as three different things, mean three different things. One, of course, is kind of a physical courthouse. We talk about the U.S. Supreme Court. When you're going to the U.S. Supreme Court, you go to an actual building. But and on the other end of the spectrum, it's also this abstract entity that's existed from the beginning of government under the U.S. Constitution in 1789. And then a third way that we talk about the court, we mean the people who currently sit on it, the 9 justices who currently sit on it. But I thought it would be useful by way of kind of providing a physical setting or context for our discussion. Here's my little attempt at animation there. So the U.S. Supreme Court, how many folks here have visited the court? It's a pretty imposing building. There's actually a wonderful description of its background in a great book on the court by Jeffrey Toobin called The Nine, Inside the Secret World of the Supreme Court. And I say that I remind myself I have a short list of some suggested books on the court. If you're interested, I brought with them. I'll put them in the back. As he describes it, I'm just going to read his description. It's very nicely written. The architect Cass Gilbert had grand ambitions for his design of a new home for the Supreme Court, what he called the greatest tribunal in the world, one of the 3 great elements of our national government. Gilbert knew that the approach to the court, as much as the structure itself, would define the experience of the building. But the site presented a challenge. In 1928, Congress had designated for the court a cramped and asymmetrical plot of land. And if you visited the court, you can appreciate that. It's kind of wedged into this sort of kind of semi-triangular wedge of space, and really very very small footprint. So how could Gilbert convey to visitors the magnitude and importance of the judicial processes taking place within the court's walls? The answer, he decided, was steps. Gilbert pushed back the wings of the building so that the public face of the building would be a portico with a massive and imposing stairway. Visitors would not have to walk a long distance to enter, but few would forget the experience of mounting the 44 steps to the double row of 8 massive columns supporting the roof. The walk up the stairs would be the central symbolic experience of the Supreme Court, a physical manifestation of the American march to justice. The stairs separated the court from the everyday world, and especially from the earthly concerns of the politicians in the Capitol, and announced that the justices would operate literally on a higher plane. Well, if you've ever climbed those 44 steps, as I had occasion to do a few times, it is quite a workout and a good stress test, as a matter of fact. It's quite steep. It takes you a long time to get up there. And the idea, I think, is to literally portray the court as sort of above the fray, right? Not maybe part of the swamp, but somehow elevated above it in some way. And now that experience isn't quite the same today as it used to be, because, as some of you may know, the front doors of the U.S. Supreme Court are now permanently closed. So you have to use what you might call the servant's entrance, which is kind of an odd situation to be in. But nonetheless, the other part of I think that the kind of elevated status of the court building says very much about the way the court considers itself as being somehow above the fray. And we can talk about whether that self-image is a legitimate one. The other thing I think that does accurately reflect the court's image of itself are the words that are above the front entrance. And who happens to know what the words above the front entrance of the U.S. Supreme Court say? Anybody? equal justice under the law. Equal justice under the law. So again, I think this too is a part of the court's self-image, and I think that image is very important when we talk about the court for reasons I'll elaborate on in a few minutes. But I want to move first to the very concrete reference to the court as a physical building. To the other end of the spectrum, the court is this abstract entity that's existed since 1789. And when we talk about the court as an entity and its origins, we go, of course, to the U.S. Constitution. And there are two key provisions in Article 3 of the Constitution. Section 1 provides the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So it's often pointed out that the U.S. Supreme Court is really the only federal court that owes its existence to the Constitution itself. Every other federal court exists solely as a result of an act of Congress, and as such, in theory, could be abolished through an act of Congress, but the Supreme Court owes its existence to the U.S. Constitution itself, and therefore cannot be abolished, and even regulation of the Supreme Court by Congress is limited, certainly by its constitutional statute. The other relevant provision is Section 2, which says that the U.S. Supreme Court has appellate jurisdiction over cases arising under the Constitution and laws of the United States. Now, a couple of things about this. One thing that's significant about the constitutional provisions addressing the court is how many things the Constitution doesn't address. It doesn't address, for example, the number of justices who will sit on the court. And that, in fact, is provided for some interesting history. Anybody happen to know how many justices there were on the court when the court began its existence in 1789? I bet you can't guess. There were 6 of them. Now, how's that? You think about tie votes? Isn't that bizarre? So yeah, there were 6. Then by 1837, the number of justices was increased to 9. Then in 1866, Congress actually reduced the number of justices from 9 to 7, primarily in order to deprive President Andrew Johnson of any opportunity to fill vacancies that might occur on the court. And indeed, Johnson is, I think he may be the only president who has never had the opportunity to fill a vacancy on the court. That was partly through Congress's machinations. He had lots of other troubles with Congress as well. That's kind of interesting, too, that many people compare President Trump to Andrew Johnson for various reasons. But in any event, the U.S. Supreme Court has always existed with the thought of it being the kind of the last resort, the final step, the top of the judicial system, the kind of apex of the judicial pyramid. And indeed, its role was seen from the very beginning as functioning as a Supreme Court, and in particular having a role in deciding important matters of the U.S. Constitution, important issues arising under federal treaties, and issues surrounding interpretation of acts of Congress. But in fact, the court's status as a major player in the political system was very much in doubt for a long time. For the court didn't actually meet for its first term at all. After it was established by the first Congress, it had no cases. It had no cases. And in the early days, in fact, it had very little business in general to conduct. So much so, in fact, that there was doubt about whether actually appointment to be a justice of the Supreme Court was a particularly important job. Now, this concern about the stature of the court, whether it would realize its supreme aspirations, was warranted by, among other reasons, the fate of the court's first major decision interpreting the Constitution. That case was called Chisholm versus Georgia. And in Chisholm versus Georgia, the U.S. Supreme Court held that private citizens could sue a state in federal court whether or not the state consented to the lawsuit. In Chisholm versus Georgia was, in fact, a lawsuit brought by a private citizen against the state of Georgia, essentially alleging a breach of contract Georgia had contracted to buy certain provisions from an individual citizen whose name actually was Farquhar. Farquhar died. Chisholm was the administrator for his estate. He sued Georgia to get the money back that he believed was owed to the estate. And the U.S. Supreme Court held that Georgia was, in fact, suable in a federal court. But the court's decision was very quickly overruled